The Minnesota Supreme Court's recent unanimous ruling has sent shockwaves through the American justice system, igniting urgent debates among legal experts, activists, and everyday citizens alike. This landmark decision is more than just a headline, it's a pivotal moment that could reshape how justice is delivered across the country. On October 16, 2025, the court boldly challenged Minnesota's long-standing jury selection process, which had relied almost exclusively on voter registration and driver's license records. While these methods might seem neutral on the surface, they have consistently resulted in the underrepresentation of people of color and other marginalized groups in jury pools. This has raised serious questions about whether the system is truly fair and inclusive. This isn't just a procedural tweak, it's a direct challenge to the constitutional promise of a fair trial by a jury of one's peers. The U.S. Constitution enshrines the right to an impartial jury, but when the pool is skewed, that right is compromised. The Minnesota ruling forces us to confront whether our justice system is living up to its founding ideals. The decision forces a national conversation. Who really gets to sit in the jury box, and does our system truly reflect the communities it serves? Are we ensuring that every voice, regardless of background, has a chance to participate in one of the most fundamental aspects of democracy? These are questions that resonate far beyond Minnesota's borders. Many states use similar jury selection methods, so the implications of this ruling reach far beyond Minnesota. States across the nation are now being called to examine their own practices and confront uncomfortable truths about exclusion and representation in their courts. This could be the catalyst for widespread reform. When juries don't reflect the true diversity of their communities, public trust in the legal system erodes. People begin to question whether verdicts are truly fair, or if they're shaped by a narrow segment of society. This lack of trust can have ripple effects, undermining faith in the entire justice process. Legal scholars and advocates argue that this moment is an opportunity to rethink how we build jury pools, perhaps by including other public records, or by reaching out directly to underrepresented communities. The conversation is just beginning, but the stakes couldn't be higher. The court's ruling signals that the status quo is no longer acceptable, and that the constitutional mandate for a fair and impartial jury must be actively pursued, not just promised on paper. It's a reminder that justice is not static. It must evolve to meet the needs of a changing society. Minnesota's moment of reckoning is a call to action for the entire nation to re-examine what justice for all truly means. As other states watch closely, the hope is that this decision will inspire a broader movement toward fairness, inclusion, and renewed trust in the American legal system. Minnesota's jury selection process has long relied on voter and driver's license lists, assuming these would capture a broad cross-section of adults. But for decades, studies have shown these lists systematically miss people of color and lower-income residents. The result? Jury pools that are whiter and wealthier than the communities they're meant to represent. This isn't about doubting jurors' fairness. It's about ensuring a diversity of perspectives in the deliberation room. The lack of diversity has fueled mistrust in the justice system, especially among minority communities. This persistent flaw set the stage for the legal challenge that would force Minnesota's highest court to finally confront the issue. Concerns about racial bias in Minnesota's jury selection aren't new. In 1993, a state task force warned that relying on voter and driver's license lists excluded people of color, and recommended expanding the sources for jury pools. Other states, like California, had already made such changes with success. Yet Minnesota's recommendations were largely ignored, and the system remained unchanged. This inaction allowed disparities to persist and even worsen. The Weeks case didn't arise in a vacuum. It was the result of decades of neglect. This time, the court was forced to address the real, personal consequences of its inaction. The issue of racial representation in jury selection became urgent and impossible to ignore through the case of Atravius Joseph Weeks, a black man tried in Hennepin County. His trial would become a flashpoint, drawing attention not only from legal experts but also from community activists and concerned citizens across Minnesota. The courthouse, once just a symbol of justice, now stood at the center of a growing debate about fairness and equality in the legal system. Weeks's defense team argued passionately that the jury pool failed to reflect the true diversity of Hennepin County, a community made up of people from many different backgrounds. They claimed this lack of representation violated his constitutional rights, raising questions about whether justice could truly be served when the jury did not mirror the population it was meant to represent. Despite these concerns, lower courts dismissed the challenge, insisting that the jury selection process was neutral and fair on its face. Judges pointed to established procedures, maintaining that the system did not intentionally exclude anyone. Weeks was ultimately convicted, but his legal team refused to accept the outcome. They launched an appeal, arguing that even if the system wasn't designed to discriminate, its results were undeniably skewed. The process, they said, produced discriminatory outcomes, whether intentional or not. The case soon reached the Minnesota Supreme Court, transforming the focus from one man's conviction to a much larger question. Was the entire jury selection framework constitutional? The stakes had grown, and the eyes of the state were now fixed on the highest court. Weeks's lawyers came prepared, presenting decades of data and the findings of a 1993 report as powerful evidence of systematic exclusion. They showed that over many years, people of color were consistently underrepresented on juries, despite repeated warnings and recommendations for reform. The legal team urged the justices to look beyond the intentions behind the system and focus on its real-world outcomes. They argued that justice must be measured not just by process, but by results, by whether the system actually delivers fairness to all. This was no longer a theoretical debate or an abstract legal argument. It had become a direct, urgent challenge to a system that many believed was fundamentally flawed and in need of change. Weeks's journey through the courts forced Minnesota's highest justices to confront uncomfortable truths about the state's legal traditions and the persistent gap between ideals and reality. The stage was now set for a landmark ruling, one that could finally demand a more equitable foundation for justice, not just for Weeks, but for every Minnesotan who would ever stand trial. On October 16, 2025, the Minnesota Supreme Court unanimously sided with Weeks, finding that the lower courts failed to address racial disparities in jury pools. The court didn't overturn Weeks's conviction outright, but sent the case back for a deeper review. The justices made clear the old standards for evaluating jury composition were no longer enough. They recognized that relying solely on voter and driver's license records underrepresents minorities and demanded a more rigorous examination of jury pool diversity. The ruling lowers the bar for defendants to challenge jury selection and puts the burden on the state to justify its methods. The message procedural neutrality isn't enough if the outcome is biased. This decision cracks open the door for systemic reform in Minnesota and beyond. In Minnesota, the process of selecting jurors begins with the merging of two major databases: voter registration records and driver's license information. By combining these sources, the state creates a comprehensive master list from which potential jurors are drawn. This system is designed to be efficient and to cast a wide net, ensuring that as many eligible residents as possible are included in the jury pool. The idea is to make the process fair and representative by using official records that most adults are likely to be part of. From this master list, names are selected at random by computer algorithms, aiming to give every eligible person an equal chance of being called for jury duty. The randomness of the selection is not in question. It's the makeup of the list itself that raises concerns about fairness and inclusivity. Many communities, especially communities of color, immigrants, and lower-income residents, are often left out. Barriers such as frequent moves, lack of stable housing, language differences, and even past disenfranchisement mean that these groups are less likely to appear in voter or driver's license records. As a result, their voices are missing from the jury box. In counties with significant diversity, like Hennepin, the difference between the actual population and those who end up in the jury pool is especially pronounced. The data shows a clear gap, with some groups being consistently underrepresented. This imbalance doesn't just affect who sits in the jury box, it impacts the entire legal process, from the way juries are selected to the fairness of verdicts and the trust communities have in the justice system. Recently, the Supreme Court has put Minnesota's jury selection process under a microscope, questioning whether it truly meets the standards of fairness and equal representation required by law. In response, legal experts are calling for Minnesota to broaden its approach. They suggest adding new sources to the master list, such as state tax records or public benefits databases, to better capture the full spectrum of residents. The ultimate goal is to create a jury pool that truly reflects Minnesota's rich diversity, one that includes people from every background, neighborhood, and walk of life. Only when every community is represented can Minnesota's courts claim to deliver justice that is truly by the people and for the people. Minnesota's ruling is already influencing the national conversation. Many states use the same flawed jury selection methods and now face similar legal challenges. Defense attorneys and civil rights groups will use this decision as a blueprint for reform. The ruling urges states to adopt more inclusive source lists and warns that outdated methods are no longer defensible. Reform will require investment and political will, but the cost of inaction is even higher: lost trust and costly retrials. Minnesota's next steps, reconsidering Weeks's case and legislative reform, will be closely watched nationwide. The likely path: expand source lists, improve address accuracy, and reduce barriers to jury service. What happens in Minnesota could set the standard for fairer justice across America. Legal scholars and sociologists agree, jury diversity isn't just about appearances, it shapes trial outcomes. Professor David Schultz notes that all-white juries have different conviction rates than diverse ones, especially in cases involving defendants of color. Diversity brings a wider range of perspectives, leading to more thorough deliberations and fairer verdicts. When juries reflect the community, public faith in the justice system grows. The absence of diversity deepens mistrust, especially in communities already wary of law enforcement. Experts see the Minnesota ruling as a courageous step toward aligning legal doctrine with social reality. By focusing on results, not just intent, the court has taken a vital step toward dismantling systemic inequality. The Minnesota Supreme Court's ruling is more than a legal decision. It's a call to build a more just system. It affirms that a jury of our peers is an active principle, not a passive promise. The decision acknowledges decades of warnings and provides a framework for real change. Its impact will be felt in every Minnesota courtroom and, potentially, across the nation. Now the responsibility shifts to lawmakers, court officials, and the public to create a more inclusive system. The path forward will be challenging, but the goal, a justice system that earns everyone's trust, is worth the effort. This is a moment for action, not just critique. The quest for justice is a collective endeavor, demanding that we all help shape a system that is truly fair and impartial for all.